Well, we've just heard from the election administrators, and they've laid out a pretty rigorous process for canvassing at the county level, then the state level, to getting to official results. There's going to be quite a bit of transparency there. There's going to be both campaigns will have opportunities to be involved in it. We're obviously looking at a situation. I say obviously. Partly because of the tenor of the post-election discussion, but also because of what happened in 2008, that legal challenges could well happen. And so I first want to start out by getting a sense of what you see as the process that would look like. Are we looking at basically a rerun of how things went with the county court kind of being the first stopping point and then moving into the appellate courts, or could there be a different process? David Lillehaug from the Frederickson firm is with us. Could you give us your sense of what this might look like in terms of steps?
Sure. Thank you very much, Larry, for the invitation. The 2010 election did go smoothly for reasons identified by the previous panelists, but I also want to mention it went smoothly in part because of the training that the Center for the Study of Politics and Governance here at the Humphrey Institute has provided to election officials, and we very much appreciate that public service that's being done. Larry, I will answer your question, but I also want to make a couple of prepared remarks if I could. This is all about numbers, which reflect the will of the people. Yesterday, Tom Emmer said, "The people have spoken, we just don't know what they said." Well, with all due respect, Mr. Emmer, we do know what the people said on Election Day. They said that they wanted a Republican majority in the State House and the State Senate, and they got it. They also said they wanted DFL constitutional officers, and that includes Mark Dayton, who a week ago, when 100% of the precincts had reported, had a lead of 8,856 votes. At 2 o'clock today, 1 week later, the lead was 8,755 votes. That's a difference of 101 votes. Now, typically, what happens in an election, as has happened many times, there will be some movement in the reporting from election night until the end of the county canvasses. That may range up to 1,500 votes. Well, everyone, I think, was more careful this year. And so the numbers are more accurate, there's been less movement, and again, Mark Dayton leads by more than 8,700 votes. Jess McIntosh, who was Senator Al Franken's spokesperson, said, "You can swim laps in 9,000 votes." It is a lot. Now, we've done some work over the last week, and we've looked at all statewide recounts in all the states of the Union in the last decade. There have been 18 of them. The average change in those recounts was 296 votes. Mark Dayton has a lead almost 30 times the average change in statewide recounts. Look at 2008, in which I was heavily involved. The change had Norm Coleman starting at 215 votes up, and he ended 312 votes down. That's a change of 527 votes. Right now, Mark Dayton has a lead that is 16 times the entire change in the 2008 recount and the 2008 and 9 election contest. And as the panelists have pointed out, there's one dramatic difference, which is the way absentee ballots are treated. Now, in his statement yesterday, Mr. Emmer identified some potential problems. First, he noted, "We've moved 1,000 votes." Again, with all due respect, not true, if you start with the reporting of 100% of the precincts. I found the statement, by the way, where he was talking about how much they'd moved really quite ironic, because the Republicans just screamed bloody murder in 2008 when there was any adjustment from election night through the canvass. Second, he mentioned the Hennepin County reporting. This is very interesting. He is essentially complaining about the fact that Hennepin County caught a mistake that was hurting his vote reporting, and they fixed it. I wouldn't be complaining about that. I would be complimenting the Hennepin County officials for that. So that one's very strange as well. He mentioned regular absentee ballots. we had only about half of the absentee ballots that we had this year that we had in 2008. It was about 250,000 last time. It was 128,000 this time. You know how many were rejected? 3,041. So even if you assume that every absentee ballot that was rejected was wrongly rejected, and that within that envelope, every single absentee ballot went for Tom Emmer, he's only chewed into 3,000 of Mark Dayton's 8,700 vote lead. And by the way, the chances of erroneous rejection, and I went through each and every one of those rejected absentee ballots in 2008, the system is a lot better this year. Number 4, he mentioned military and overseas ballots. 1,900 of those were submitted and only 10 were rejected. Give Representative Emmer every one of those 10 and assume they were wrongly rejected. He hasn't made much progress. And then finally, there are some issues about vouching in one Minneapolis precinct. Those are the things that have been identified. But there are storm clouds on the horizon. If you read the Morning Star Tribune, here's a quotation from what was identified as a high-level Republican operative who spoke on the condition of anonymity. He said, quote, he or she said, quote, "I don't think there's any downside to keeping this recount going on as long as possible. If we keep the process going, there are opportunities for us in the upcoming legislative session." Well, Representative Emmer has the right to decide not to proceed with this recount, as election official Joe Mansky said. He has a right to do what he wants to do. However, if Mark Dayton had called me now, a week after the election, and said, "I'm down 8,700 votes," I would tell him, based on my experience in 2008 and the experience around the country, that he should call his opponent and congratulate him and wish him well. The option of going through this recount so as to set up an election contest where there aren't any real issues, and just to keep that going, to keep Governor Pawlenty in office, is one that I think a lot of people in this state would consider un-Minnesotan, and they would consider it a hijacking of government. Because I will tell you one thing, even if Representative Emmer does not know what the voters said on election night, I would suspect even he would concede that they did not say they wanted Governor Pawlenty to remain in office after his term has expired. I think that is pretty fair to say. Speaker-to-be Kurt Zellers first said that the Republicans would not try to pass legislation early in the session and put it on Governor Pawlenty's desk. And then yesterday, late afternoon, his staff walked back part of that statement. So there are storm clouds on the horizon, but they are entirely, at this point, within the control of Representative Emmer. And I would hope, whatever his choice on going through 2.1 million ballots and having hundreds of thousands of dollars of taxpayer money spent, and our public officials responding to data practices request, that at the end of this manual recount, he will do the right thing.
David Lillehaug was attorney at the Frederickson and Byron law firm and was one of the key lead lawyers in the 8-month recount when we had the Coleman Franken process in 2008. I want to turn to Fritz Knaak, who is not involved in this recount. Dave Lillehaug is involved.
And you can be sure I don't have any prepared remarks on behalf of Tom. God, I miss you, Dave. I really do.
Fritz Knaak is...
I miss you too, Fritz.
Fritz Knaak is the managing partner at Knaak and Cantrude, and is president of North Oaks Title. I want to kind of raise a question about how you think about recounts. Minnesota law says that that the focus is on material violation of election law that would change the outcome. Mm-hmm. So it's not just, a mistake here, a mistake there. It's that there's a violation of the law, and that violation would change the outcome. What class of problems do you think that the Emmer campaign should be looking at to meet that standard?
Well, I think what they're looking at, or what they should be looking at, is to see whether there are any significant discrepancies, at least initially, in the numbers. And both these campaigns, one of the advantages that we've got right now, Larry, is we've been through this before. In fact, we're actually kind of fortunate that this isn't the third go-around. It came very close in 2006. People forget. The bottom line is, everybody's going to be looking at the numbers right now, scrutinizing them very closely. As David knows, and I know is the case on the other side, every conceivable piece of email, every conceivable request, every conceivable piece of research and responses on data practices, everything like that, it's all been done. And so really I'm anticipating right now that you're going to see a lot of people going through a lot of activity by rote. That's what I'll call it. They're going to be getting the information, comparing what they're being told by the counties with the actual data, as you've heard, that's being provided. I'm sure that's going on both sides, and I'm guessing that by the time the canvassing board meets, both sides are going to have a very good idea whether or not there is any significant drift. I mean, one of the odd things that I recall about the Coleman Franken recount was the fact that the drift did seem a little one-sided. It all kind of, and that's what got people concerned back then, you'll recall. It seemed like all the bleed was on our side and not on the other side. David's right. Usually what you get in a situation like this is, you lose 50 here maybe, or 5 here, 10 there, and it tends to balance out more or less in the end. I think you're going to see a lot of scrutiny to see whether the reporting is that way. The other part of this, though, too, is and of course, I know this is going to be startling, but there's some politics involved in this. And the bottom line is Republicans especially are feeling pretty ouchy about the last outcome. And, you're still dealing with a situation where the final result was 325.
312, but who's counting?
I knew I could ask you. And the bottom line there, though, is that, there's still like 12,000 uncounted ballots. And so Republicans look at that shadows over it. Anything that has to do with the recount, they're very, very suspicious of collectively. And that's why you're seeing the kind of attitude, I guess, is what I describe it as, that you're seeing on that side.
Thank you, Fritz Knaak. I just want to come back to you, though. What you've described as an empirical process.
Right.
Count the ballots, count the votes, look for discrepancies. Is that the way this is going to play out? Is it going to be an empirical process? You've talked about kind of the sore feelings about uncounted ballots last time, not getting that full count. Do you have a sense that kind of empirical approach of looking at discrepancies, making sure the ballots have been counted, that will be the determinative factor with regard to any legal challenge?
Actually, I do. I think that in the end it is about the numbers. I haven't heard any serious discussion inside the Republican Party about some vast conspiracy to keep Pawlenty in office. I know this is a dark fear among the more progressive wing of the Democratic Party, and I enjoy watching them squirm. But the reality is that's not going to happen. That's not why the people that are Republicans in the legislature got elected, why that majority is there. So I don't really see that as being an issue. It will ultimately come down to numbers. And there will be gut check points, what I call gut check points throughout the process. One will certainly be when they arrive on the 29th. It looks now like there's some momentum in the direction of a recount. I don't think, notwithstanding all of the powerfully shaming language we just heard and we'll be hearing a lot more of, I suspect that isn't going to matter much. I think they're probably going to see people wanting to have the recount done. I'd agree with Joe Mansky, by the way. I think that number is probably a little higher than it need be. But
so Fritz, you're in.
Hold on 1 second.
I'm sorry, you're asking the questions.
Hard, isn't it?
Council, stand down. Mr. Knaak, I just wanted to be clear. You were referring to Joe Mansky on what number?
When he was talking about something that needs to be reviewed again, I think the automatic recount number that we have here is a bit high. And I'm not disagreeing that I think that's going to be a mighty, mighty steep hill for the Republicans to climb.
And just to be clear then, that you expect the numbers to speak here.
Yes.
This is not going to be a situation where, some hurt feelings are going to lead to a long, drawn-out 8-month process to kind of, look under every blade of grass, even if it's not going to.
Well, Larry, don't minimize the hurt feelings part of it. It's not really about that. I think there's a suspicion is what I would characterize it as, and it may well well be that we're going to have to do another run, and frankly, let's face it, I mean, the politics in this state has changed pretty fundamentally. I wouldn't be at all surprised if I were Amy Klobuchar. I'd be sending a retainer this guy's way pretty quick, because in 2 more years, you've got essentially the same election. Are you ready?
Is everybody recording this, by the way?
You know, and who knows? But I think that within a couple of years, there's a fair likelihood that we're going to see another close election. So to gain confidence in the system, I think we almost have to go through this exercise.
I agree with you on that. And I think the exercise last time not only produced an outcome that was trusted, but that you saw Norm Coleman step up, and it had to be a crushing moment and say, I accept this. It disappointed me, but I accept it. And to get that legitimacy,
right,
it's a huge outcome. So, you know, that's why we have a process. That's why so much effort is put into getting the rules right, why the legislature keeps coming back to this. So I agree with you. David Lillehaug, let me ask you a question about if this does go to the courts, where that would start, and how you think the courts would look at a challenge to the certified results that look to be frivolous. That is, it didn't meet the standard in Minnesota state law of material violation of state law that changed the outcome.
A good question, but I want to take one step back as I work into that, which is the state canvassing board. If we do go through our manual recount, then there is going to be a declaration of the result by the state canvassing board, which, by the way, is a constitutional entity. It is created by the Minnesota Constitution. And when you look at who Secretary of State Ritchie has put on the state canvassing board this year, most certainly nobody could claim that those judges as a whole represented any particular political party. So once the state canvassing board renders the declaration as to who got the most votes, then the losing candidate faces a pretty fateful decision, which is, do I start an election contest? And an election contest is a lawsuit. It is a lawsuit that's heard by 3 judges, and it's a fast lawsuit. At least it's fast up to the time you start the trial. It has to start within 20 days after the election contest petition is presented. But as you saw in 2008, if you have a lot of complexity and you have a lot of documentation, then the trial itself can go on for a long time. We went for 7 weeks. And then there was a period of time where additional ballots were opened, then the 3-judge panel rendered its decision, and then there was an appeal to the Minnesota Supreme Court. It didn't get wound up until June 30th, and Al Franken was not sworn in until July 7th. Now, not having 2 senators is an important and weighty matter, but I would submit that not having a duly elected governor in place is potentially a more significant matter, especially with the matters that the state is facing in the upcoming legislative session. Not just a budget, not just our participation in the national health care plan, but this is a redistricting year as well. And so maybe people are a little antsy on the other side, but let me suggest that there are a lot of people who are antsy about the prospect that a new legislature would be pushing through a new redistricting plan to try to lock in an advantage for 10 years. And such legislation would be signed by a governor whose term has ended. And so there's a lot of concern about it, and I think rightfully so. Because especially when you're talking about an 8,700 vote lead, then there does seem to a lot of people, no question, but that Mark Dayton was chosen as governor of the state of Minnesota.
Mr. Lillehaug, you've done a great job with the clouds. I think we all see the clouds forming, this doomsday scenario that you see. But I want to get back to this legal question about how the courts might handle a situation where they're not seeing where those 8,700 votes are coming from. It's more of a theoretical argument where they're, unlike, let's say, back in 2008, you could point to clusters of votes that would meet the standard or at least provide prima facie evidence of it. Mr. Knaak, can you give us a sense of how you think the courts would look at a situation in which the arguments were more theoretical rather than empirical in terms of number of votes that were cast and counted and certified that violated state law and would change the outcome of this of the race.
Well, the interesting part of the contest process itself is that it's actually another full recount, technically speaking. And people suggest that somehow you can impede or do the kinds of things that, I mean, if you really wanted to impede an election and take your time, what you do is say the whole thing is screwy and let's start it all again. The reality is people aren't going to do that. They're going to stipulate to numbers. It does come down to numbers, and at some point, we had sanctions threatened against us. I mean, it's conceivable under the right circumstances that a judge could threaten sanctions, but I just am not expecting that. I think that there is just too much of a downside. I guess it gets back down to politics. I mean, there's just too much of a downside, even for Republicans, to drag this thing on and on and on. I think there's going to be an important moment in December. If things go the way I think most people expect them to go, I would agree with David. I think that there's going to be a judgment that's going to be Tom Emmer's to make. Right now, as I see it, a lot of what's pushing this thing along is the hard feeling and the worry, I would say, that Republicans are feeling, and I think most of this is actually being pushed through the party.
So let me just ask a kind of precise legal question,
okay,
which is about petitions for dismissal or petition for summary judgment. This is where I'd really benefit, Mr. Knaak, from your legal judgment, whether you think a judge would be more inclined to grant that if they see a lack of enough votes there in terms of the numbers that would change the outcome and be votes that were in violation of Minnesota election law.
As a matter of law, I think that if you were in a situation like that where a judge saw that the decision either way would not affect the outcome, ultimately the answer is yes, the judge would. And I've seen judges do that, by the way.
And when you say not affect the outcome, you mean you need to see a pile of 12,000 votes or 10,000 votes, whatever it is, that you could say, yeah, there's prospect there, there's something in there. It's not just kind of pulled from thin air. There's something going on here we have to look at.
Well, let's take it. We'll take the numbers here. I think there's 3,000 absentee ballots, and let's say that the entire argument that was left on the Emmer side had to do with improprieties in the absentee ballots. They may want to go through and actually do, because the parties are entitled to do that, they may want to go through, if there are significant issues, go through those. But as a practical matter, the judge at some point, or the judges, could at some point say, it isn't relevant. You haven't raised a reasonable basis for that contention, and in the end, it doesn't matter because we're talking 8,500 as opposed to 3,000.
Thank you, Mr. Knaak.
We briefed that issue in 2008, and it is the law that you need to show that if the other side's contentions, if your contentions are true, that it will change the result. And so even with respect to absentee ballots, if the single allegation in the election contest was, boy, they improperly rejected 3,000 absentee ballots, case should be dismissed because, again, if every single one was erroneously rejected and every single one was assumed to be a vote for Tom Emmer, Mark Dayton would still win the election.
Yeah, and the interesting thing, again, this gets back to my earlier point, there is no aspect of this that hasn't been briefed or argued or, all the technical points have been made and raised, and it really, I think, is going to come down in the end to numbers.
Mr. Knaak, I want to get your views about the appointment of former Chief Justice Eric Magnuson as the lead attorney for Tom Emmer. First, do you see any ethical issue with Mr. Magnuson doing this after he'd been chief?
No.
And do you read anything into it other than trying to get the best legal talent you have? There's some that are saying this is like the beginning of a scorched earth, a policy, or is it just, look, we want to get the right call in November or December, and this is one of the best legal minds who has been through this just a few years ago?
Well, you want the right team in place, and you want it out there. It's perfectly conceivable that Mr. Magnuson won't have to argue a single thing. He's being designated as the litigation team leader on this, and my expectation, quite honestly, is that he may not make a single argument unless they have him representing the campaign in front of the board.
So part of his role could be as counselor to Mr. Emmer and saying, here's how I read the law, here's how I'm looking at the ballots, and as you were just mentioning a moment ago with regard to potential summary judgment request or dismissal, he could be providing that kind of legal counsel.
Well, and I'm anticipating, I mean, as was the case, I'm sure, in the Franken campaign, I mean, we had separate tracks, separate groups doing and anticipating different kinds of things. It may well be that they have a group right now that's anticipating the legal challenge, and he's going to be heading that up. But as a practical matter, again, I mean, I Godspeed, but I just don't see what his role will be unless there are appeals or anything like that. And right now, this is all about numbers.
Mr. Lillehaug, you look like you want to jump in.
He always does.
We're reserving judgment. I personally have enormous regard for Eric Magnuson, but he's the lawyer, and the question is, who's the client and what are the client's wishes, goals, and desires? I was a little concerned yesterday in Mr. Emmer's press conference when he was asked very directly if he would be making the decision, and he kind of implied, well, he would, but other people would be too. Well, I can tell you unequivocally, in this, Charlie Nowen, the lead counsel for the Dayton recount effort, and I have one client, and his name is Mark Dayton. And in 2008, I had one client, and his name was Al Franken. So it's very important that the candidate come to grips with what has happened in the election. I run for office, and I lost, and it really, really hurt. And I bet it hurts even more when you come in a lot closer. And there's not that finality. But at some point, there has to be finality.
Well, that's moving into the area of kind of speculation with regard to what Mr. Emmer might or might not be thinking. I'm sure, Mr. Knaak, you've heard, as I have, that there's actually some disagreement among Mr. Emmer's supporters about whether to contribute money and how far this should go. There are different views in the governor's office, who's, by the way, has got a book coming out to launch a potential look at the presidential race. The Republican leadership in the House and Senate might have views. So this is going to be a complicated calculus for Mr. Emmer that may well go beyond. Would you agree with that?
I would, and I think those are the things that he has to factor in. I agree with what David's saying in terms of who ultimately the lawyers are answerable to. My sense when I heard Tom saying that was that he was concerned and thinking about all of those different constituencies that he will have to think about as this moves forward.
Mr. Knaak, I want to come back to an issue that was raised when we had our election administrators up here about the reality that there are some illegal voting. There's some illegal voting going on. And it sounds to me, election administrators, they don't think it's very extensive. It's turned over to the sheriff's office and the county prosecutors. Do you think the legislature ought to look at that the penalties ought to be increased or some further enforcement? Do you see a need there for further action?
Not yet. I mean, and I've actually handled a couple cases like that. Students are notorious for voting in two places. I had one particular case. In fact, Mr. Mansky's county, where somebody actually was forgot, and he had an enthusiastic professor, which occasionally you tend to be, and you end up with all kinds of people. I'm going to vote. You better vote now. And he went and voted, and he forgot that he'd already voted absentee. And of course, by the way, for those of you that are thinking about doing those things, eventually you get found out. And if you learn anything in the system, it's transparent, it is remarkably thorough, and there is very, very little room, I think, and we're getting better at it, for that kind of mistake. Does it happen? Sure. I can think of one case that I'm aware of where a felon voted. Didn't know. Well, somebody, in that particular case, I believe him, by the way, no one bothered to tell him, oh, by the way, here's your $8, your bus ticket, and don't vote. I mean, it wasn't something he had been told. And so it's, those things happen. It's remarkably rare.
Mr. Knaak, we're just almost out of time. I want to ask you, as a veteran of the 2008 recount battle, what your takeaway is from having looked very, very closely at the election administration process here in terms of its integrity, its transparency, and the independent checks that exist. Does this give you confidence that we'll get it right in this governor's race, or do you have major questions?
I have no major questions. I think it was, and I think David certainly would agree, he liked the outcome obviously better than I did. But I think that one of the things that we learned in the last, in 28, was the fact that it really is a good system. And improvements have been made. And a couple more could be made. But I think we do this about as well as anybody does. And I don't say that with any sense of smugness, but I honestly do believe that this one will come out right.
Mr. Lillehaug, do you agree?
We do have a good system. There is a judicial finding that we have one of the best systems, if not the best system in the country. And in 2008, we found the soft spot in the system pretty quickly. By this time, 1 week after the election, we were fully embarked on the issue of improperly rejected absentee ballots, as laid out in the new book by Jay Weiner called This Is Not Florida, which is just an excellent book. So if Representative Emmer or anyone else has any major issues with this year's election, I would assume they would know them by now, and I would hope they would be disclosed to us in the very near future.
Speaking of disclosure, did you get some kind of cut for that little?
I want to thank Dave Lillehaug for coming and joining us, prominent lawyer here in town and partner at the Frederickson firm, and Mr. Fritz Knaak, also a prominent lawyer in town, who was a partner in the Coleman challenge back in 2008. Thank you very much. Thank you to all of you for joining us.